Hi, I'm Rory Weiler, and I'm here to talk to you this morning about the maintenance guidelines which took effect January 1st of 2015. The first thing that we have to discuss is whether or not the maintenance guidelines are applicable to all divorce cases, whether or not, regardless of the party's income. And the answer to that question is no, they are not. The maintenance guidelines specifically apply only to those cases where the combined gross incomes of both husband and wife are less than $250,000. Also, the maintenance guidelines do not apply to certain situations where the maintenance payor has a prior obligation to pay either maintenance or child support to a previous family. The question becomes, when did the guidelines take effect and what cases do they actually apply to? First of all, the guidelines took effect on January 1st, 2015. They apply to all cases that were filed on or after that date. However, there are some nuances as to whether or not they apply to cases that were filed prior to January 1st of 2015. And the answer to that question is a little more muddled. It seems to be the bulk of authority backs the idea that any case that was pending on January 1st, 2015, but unresolved, would have the maintenance guidelines apply to it. The nuance there is whether or not the guidelines change an existing obligation, and frankly, there are a lot of different cases that address the applicability of the guidelines to those pending cases. The prevailing wisdom at this point in time is that if you had a case that was filed and pending on January 1st, 2015, the maintenance guidelines, assuming the other requirements are met, are going to apply. However, you should carefully research, and I would commend you to look at the case of Commonwealth Edison versus Will County, because you might be able to make the argument, and this issue has not been decided by any court of law at this point, you might be able to make the argument, if you're trying to avoid application of the guidelines, that in fact the guidelines do not apply. Then we have the situation where maintenance is being reviewed after a judgment is entered prior to January 1st of 2015. The question at that point, of course, is do the maintenance guidelines apply to maintenance reviews? And again, there's no definitive law on the topic, although once again, going back and looking at case law, it appears that the guidelines would not apply to any maintenance review that occurred pursuant to a judgment that was entered prior to January 1st of 2015. However, you should carefully note that there are plenty of arguments that can be made under the statute in conjunction with either trying to apply the guidelines or trying to avoid the application of the guidelines in maintenance review cases. Under the existing statute, we have to figure out, or we have to determine rather, how we handle the application of the guidelines in conjunction with the calculation of child support. As most of you know, there are certain statutory deductions that are set forth in Section 505 that allow the court to determine what the proposed payor's actual net income is going to be. With the application of the new statute effective January 1st, 2015, the amount of maintenance being paid in the case pursuant to the statutory guidelines has been added to Section 505A as a deduction from the payor's gross income to get to the payor's net income for the purposes of calculating that payor's child support obligation. The most important thing to remember about the maintenance guidelines is that we are in some manner blazing new ground here. There are a myriad of arguments that can be made in each and every case as to whether or not the guidelines should apply or should not apply. And frankly, there are a lot of cases out there that you should familiarize yourself with in order to make a determination in your case as to how you're going to argue that position. So as is the case with a lot of family law legislation, we are in a position where at this point in time, until we get more guidance from our appellate or Supreme Courts, many arguments can be made on both sides of the equation. And you should, of course, familiarize yourself with those cases and with those opportunities.